Welcome to the Farrar's Building 7th Chambers webinar. I'm very pleased to be presenting this webinar this afternoon, the title of which is COVID's Child, Lifting the Lid on Litigation After Lockdown. Before I start, I would like to thank you for joining, but also to remind you that there is a question and answer tab you can click on if you have any questions during the course of the webinar, and I will happily deal with those at the end if I can immediately. If I can't immediately, then I will come back to you, or please feel free if you think of any questions after the webinar. Feel free to email into Chambers, and I'll be more than happy to respond to you in that way. Just a little bit about me before I start the PowerPoint. I'm Howard Cohen, in case you didn't know who I am. I'm called in 1999. My practice is almost entirely personal injury work. It's a mixture of claimant and defendant work. And my work ranges from fast-track work to high-end multi-track work as well, dealing with a mixture of spinal, brain injury and other related areas as well. There is often a focus of fraud and fundamental dishonesty in the sort of work that I do. Right, with that said, I'm going to try and share my screen, and let's get started. There we are. So, COVID's Child, lifting the lid on litigation after lockdown. COVID's Child, what do I mean by that? Well, what I mean is really what comes after COVID. What is COVID giving birth to from a litigation perspective, and in particular from a personal injury litigation perspective? What can we expect to happen once we all hope COVID moves on, and where will that leave us? Now, to a certain degree, we are stargazing, because we can't tell, no one knows at this stage where the future really lies, and what we can expect to see arising out of COVID-19 from a litigation perspective. But one thing is for sure, and that is that we are currently in the birthing suite, if I can use the analogy of childbirth, simply because COVID, we're now 3 months into lockdown almost, and approaching 6 months since the world became aware of COVID-19. And so what we're seeing now are the initial consequences of a virus, really, that the likes of which the world, certainly in nobody's lifetime, has ever seen. Current statistics are that, as at today, 42,647 deaths and in this country, and 305,289 cases of COVID-19 in this country alone, and worldwide we're looking at something like 500,000 deaths. So it's a substantial and a terrible pandemic, and it's going to have ripple effects that will be felt worldwide, but certainly in this country for many years to come. So in terms of the birth of COVID's child, what do we know so far? What's happening now before we take a little look into the future and see what will be happening a few months or years hence? Well, the obvious impact of COVID-19 now is the court closures that everyone has seen and is aware of. Because it's having a massive impact on litigation generally, not just the criminal courts, the civil courts are also hearings being vacated left, right and centre. And the difficulties that all practitioners and all legal representatives are having in trying to keep their cases up to date and progressing. I imagine it would be a rare practitioner, PI practitioner, who could say that their caseload hasn't either slowed down or dropped as a result of what is happening out there. One particularly useful source of information which I commend to everybody is the HMCTS, the Court Service Twitter account, because on the account they issue a weekly bulletin, a summary of where the court service is, which courts are opening, which courts are not. And it's very useful, and in fact there was an update yesterday which indicated that a further 16 courts are about to open on top of the 159 courts that have remained open throughout the pandemic so far. And if it helps, if any of your cases are being heard or meant to be heard in Barnet, Derby, Chesterfield, Southend, Horsham, Canterbury, Salisbury, or Merthyr Tydfil, then you're in luck, because there will at least be provision for physical hearings to take place in those courts. It's worth remembering, though, that just because some of the courts are reopening very slowly, that doesn't mean that there's no risk attached to attending those courts. And I quote an article from the Wall Street Journal from last Thursday, an article which said this, in which there was a quote which said this: "It's not common to contract COVID-19 from a contaminated surface, scientists say, and fleeting encounters with people outdoors are unlikely to spread the coronavirus. Instead, the major culprit is close-up, person-to-person interactions for extended periods. Crowded events, poorly ventilated areas, and places where people are talking loudly or singing maximize the risk." Now, if one thinks about a standard courtroom, person-to-person interactions, extended periods, people talking loudly, all of that chimes quite strongly, in my experience, with what happens inside courts every day up and down the country. So, as I say, just because some courts are reopening slowly, that's not to say that there are not risks attached to that. And it's also worth remembering what the civil listing priorities are for cases, so that we have a better idea of what cases are going to be heard in courts and which are not. And so far as civil cases are concerned, there are two groups of cases that HMCTS wants to get heard as a matter of priority. Firstly, you'll see here any application in cases listed for trial happening in the next 3 months. Any application where there's a substantial hearing listed in the next month. And then all multi-track hearings, including trials, which the judge considers to be urgent and B, suitable for hearing either remotely or in a physical hearing, and then also appeals in these cases. So that's priority civil work that the courts most definitely want to get listed as soon as possible. Not to say that they'll be listed in a physical courtroom, but that those cases will be listed nonetheless for a hearing before a judge. The other class of case which the courts want to have heard is simply under the generic title of other work which should be done. All other applications, hearings, trials, which, subject to staff support and listing capacity, the judge considers 1, should be heard, and 2, are suitable for hearing either remotely or in a physical hearing. So listing is a judicial function. It's entirely down to the judges to decide what they want to do, what they want to list, but they really have a very broad discretion in terms of what they can list, what they need to, what they don't need to. And there is already quite a large and growing body of case law which sets out different judges dealing with difficulties arising out of COVID in different ways. And that will include, for example, physical hearings not taking place at all, trials not taking place at all, to those where trials in person will take place in certain circumstances with all the necessary precautions and protections. And even in one case, a situation where one party would attend trial in person, whilst for various distancing reasons, the other party was acting remotely. So much more flexibility in terms of how cases are being dealt with according to the facts of each case. Now, what is the impact of the COVID-19 difficulties on, I say, COVID's other children? What I really mean by that is existing PI cases. Cases that were, and plans within PI litigation that were afoot prior to March the 23rd when lockdown began. Well, the first one, obviously, the whiplash reforms have been delayed. Those reforms initially due to come into force in April 2020, then August 2020, and now April 2021. And these are the reforms, as I'm sure many of you will know, which include tariffs for whiplash injuries of up to 2 years, raising the small claims limit on standard motorist type claims from £1,000 to £5,000, and for other what they call vulnerable road users, that's cyclists, pedestrians and so on, from £1,000 to £2,000. Second impact, Swift and Carpenter, the Court of Appeal case that is dealing with the question of accommodation claims. That was delayed, due to be heard back in March. In fact, day one of the Court of Appeal 3-day hearing was today. So thankfully, the delay was only about 3 months, caused by the problems raised by COVID and so on. Many of us will recognise the fact that fewer claims appear to be being litigated, simply as a result of, first of all, less accidents. Second of all, solicitors and representatives not in the office. People are simply unable to react and to deal with the workload that they would normally be dealing with. But that segues into the fourth point, which is that even cases that have already been issued and where litigation is pending, the nuts and bolts of bringing and proceeding with that litigation simply can't proceed at present. Now, that might be problems with service, because solicitors are, and defendants, whoever they may be, insurers or whoever is accepting service of proceedings, they may simply not be in the office, and they may not have received or seen or known about proceedings, which obviously leads to difficulties and delays. Also, delays with medical examinations, claimants simply being unable to see medical experts or be examined by them, either because they themselves are isolating, or because of distancing problems, or because the doctors themselves aren't seeing patients physically at the moment. And fifthly, another impact that COVID has had upon existing litigation is that there are, of course, now these additional practice directions introduced to CPR 51, which again have led to delays and other specific provisions that are thought to have been necessary because of the difficulties with COVID. And one example of that is the extension that parties can now make to deadline dates from 28 days, without resorting to the court, from 28 days to 56 days. And all of that simply serves to slow down litigation yet further. So that's the sort of introduction, if you like, to COVID's child or children. And I start by looking really at what COVID-related claims are we currently aware are coming, are in the pipeline. The first of these is a specific non-PI claim, but it's the claim being brought by Airlines UK, which is a collection of airlines led by IAG, the owners of British Airways, EasyJet and Ryanair, trying to bring judicial review proceedings against the government's 14-day planned quarantine period. Now, that quarantine for travellers coming back to the UK, having travelled abroad, was introduced by the Health Protection Coronavirus International Travel England Regulations 2020. And the plan was, it came into force on the 8th of June, in fact, effective for 12 months. And the plan was that those who don't self-isolate when they come back into the UK for 14 days would be subject to a £1,000 fine. You may have read in only this afternoon's media that the government is, I think, planning to create up to 10 air bridges. And I think these, so from what I read, these plans for air bridges, which will avoid the need for quarantine, are quite advanced with, as I say, up to 10 countries. It may be then that the need for these judicial review proceedings, this claim, may not be necessary. The need for it may be blunted, but nonetheless, the thrust behind the litigation from these airlines really on two bases. The first is that it's an irrational thing to bring in regulations requiring a quarantine 3 months after lockdown. So travellers have been able to travel to and fro, in and out of the country for 3 months before these quarantine regulations were introduced, and that is said to be irrational. And the second basis for the JR proceedings being brought is that the regulations are procedurally unfair, in the sense that the government simply didn't consult with the airline industry before introducing and bringing into force these regulations. So that's the first set of litigation that we're aware of now arising out of COVID. The second type are clinical negligence claims, and there's one in particular that we are aware of. It's the case of Talati, against the Secretary of State for Health and Social Care. And it's a clear neg case arising out of the government's slow response to COVID-19. The claim is being brought under the Human Rights Act, in particular because of an alleged breach of Article 2 of the ECHR, right to life. Now, the story behind this is that Mr. Talati, an NHS worker, brings a claim. He and his wife and his parents all contracted COVID-19. His father died as a result of respiratory failure due to COVID-related viral pneumonia. In a nutshell, what the claimant argues is that the state didn't do all that it reasonably could have been expected to do to avoid a real or immediate risk to life. And broken down, what he says is that he didn't do enough to protect the public before introducing the lockdown on March the 23rd. According to Mr. Talati, he says that the government knew enough, both from events around the world and the scientific research, that by the 10th of February, that's about a month and a half before the date of lockdown, that the government knew enough to know that lockdown was required at that stage. Now, what happens with that case is obviously going to depend upon how much the government knew, the state of knowledge, and there are obviously going to be difficulties with causation as well. How does one prove that had there been a lockdown, that NHS workers wouldn't have caught COVID-19 in any case? But Mr. Talati obviously feels strongly. He was the first out of the traps on this, and so much so that he has set a crowdfunding target of £50,000 to finance his litigation, which, as at just a few days ago, had raised almost £37,000 from a total of 1,642 pledges. So clearly there are a lot of people out there who want to support Mr. Talati in what he's doing. The third area of COVID-related claims that we know about are those happening abroad, so less useful, although they may point to where we may be heading in due course. An article in last week's Daily Mail suggests that in America there are already more than 770 lawsuits filed, 250 of those in New York, according to a database created by one international law firm. And those claims really vary from the families of deceased relatives in a care home in Atlanta suing the care home because because they were serving meals on a group basis, that's to say sharing food amongst plates with various residents of these care homes, not taking care to isolate or separate catering arrangements. Also class actions, including against Ticketmaster over cancelled live events, and travel claims arising out of cancelled flights for which refunds haven't yet been forthcoming. Now, really the meat of what I wanted to talk about this afternoon was COVID's children from a personal injury perspective. What cases can we expect to see coming down the track from a PI perspective? And as I see it, there are likely to be four main areas where these claims are likely to be made. The first is in the area of employers' liability. Employees either working from home or remaining in work or about to go back to work who contract the virus. What causes of action are they likely to have, and how are they likely to go about pursuing claims for that, of any injury or loss that arises? Secondly, public liability, so people who go shopping, go to somebody else's office, go to the gym, the library, wherever they might go, and also contract COVID-19 simply because of a failure to take care on the part of occupiers of those places. Clinical negligence, and finally, perhaps slightly bizarrely, claims arising out of motor cases, and we'll come to that in due course. Before I break down those and look at each of the four of them, just some introduction behind what I'm going to say next. In terms of employers' liability, what we know now is that 9.1 million people have been furloughed That's 25% of the UK working population, and that's of a total of just over 1 million employers in the UK. So a quarter of working people in this country have now been furloughed at some stage over the last 3 months. So from an initial point of view, one would have expected there to be fewer EL, employers' liability cases, simply because people aren't at work. And there may be something in that. And the same may be true of public liability cases, in the sense that where gyms and libraries and shops, places of worship, have all been closed for the last 3 months, it may well be that the numbers of cases arising or that could have been brought within that last 3 months obviously simply won't be there. Obviously, that doesn't change the fact that in the months to come, there are still likely to be cases, probably quite significant numbers of claimants who will contract COVID, either from their workplaces or from public places that they visit, and will therefore be looking to see what options are open to them. Also, because there's been a pause at the moment in terms of people bringing their claims, once lockdown rises, once lockdown ends, and people are able to pursue their claims again with solicitors they can actually go and visit, and people who are in the office, then it may be that we see an increase in numbers of EL cases, particularly and PL cases, that had either been intimated or issued pre-lockdown, but been on a go slow ever since. So it may be that there's a rather long and large catching up period once lockdown is over. So what cases then, employers' liability first of all, in what ways can we expect COVID to lead to an increase in employers' liability cases, and in what way are those cases likely to be new and novel because of the issues that COVID has raised? Well, the obvious place to start are the Personal Protective Equipment at Work Regulations 1992. What Regulation 4.1 of those regulations says is that every employer shall ensure that suitable personal protective equipment is provided to his employees who may be exposed to risk to their health or safety whilst at work, except where and to the extent that such risk has been adequately controlled by other means, which are equally or more effective. So just worth pausing there for a moment. The PPE at work has to be suitable, and it has to be provided except where there are where the risk has been controlled by other means which are at least as good. Now bear that in mind, because we're going to come to a point arising out of that in just due course. Now Reg 4.1 applies to employers. Reg 4.2 applies to those who are self-employed, who may still owe duties. And Regulation 4.3 defines what suitable PPE is. You'll remember under Regulation 4.1 that the employer shall ensure suitable PPE is provided. PPE shall not be suitable unless it's appropriate for the risk or risks involved and the conditions at the place where exposure to the risk may occur. And if we skip to little d, so far as is practicable, it's effective to prevent or adequately control the risk or risks involved without increasing overall risks. So PPE needs to be suitable, it has to be appropriate, and it's got to be effective to prevent or control the risks to claimants. The PPE regulations also deal with duties to risk assess, inform, train, maintain and replace personal protective equipment as well. And we of course are reminded that under Section 69 of the Enterprise and Regulatory Reform Act, a breach of the PPE at Work Regulations 1992 does not confer civil liability. So even if there is a breach of these regulations, that breach only goes to the question of negligence. In other words, did the employer do what was reasonable to protect his employee against reasonably foreseeable risks? Now, when we're talking about PPE, the most obvious PPE that I think applies to COVID-19, twofold really. One is face masks and face coverings, and the second one is gloves. And I think really the face masks and the face coverings are the ones that we should focus most upon, because they're the ones that one sees most often and that most people seem to be most concerned about. And of course, there is this distinction between face masks and face coverings. Face masks tend to be masks which are surgical or medical in nature, whereas face coverings can be anything from paper coverings to the sorts of face furniture. I can put it that way. You can see people like this lady in the slide wearing as well. The question is, are face coverings PPE? And what guidance does the government give us about face coverings? I'm going to leave face masks and surgical masks to one side, because the guidance given by the HSE is that surgical medical face masks is only appropriate in a clinical setting. And most of the claims that I'm talking about will not be those arising from a clinical setting. So I'm talking about face coverings. So what guidance have we received from the government and the HSE and Public Health England to help us to know the way forward? Well, this is an HSE document entitled Face Coverings and Face Masks During the Coronavirus Outbreak. And you may be surprised to read that according to the HSE, wearing a face covering is optional in most circumstances and is generally not required in workplaces. They are not an effective way to manage the risks for coronavirus, and you should not rely on them. The evidence suggests that wearing a face covering does not protect you, but it may protect others if you were infected and have not developed symptoms. Face coverings are not classed as PPE. And it goes on, they are not manufactured to a recognised standard and are not CE marked. They do not provide a proven level of protection for work risks, such as dust and spray. And it finishes by saying this: if people choose to wear face coverings at work, you should support them. Now, that's as may be. It might come as something of a surprise, given, first of all, the fact that everybody and his wife, when you go shopping, now seems to be wearing face masks, but also the significant contrast, as it seems to me, is that between the HSE guidance that I've just read to you and this, which is that according to the Health Protection Coronavirus Wearing of Face Coverings, not face masks, note, face coverings on Public Transport England Regulations 2020, forgive me, that's my mistake. According to Regulation 3.1, it says no person may without reasonable excuse use a public transport service without wearing a face covering. And the penalty for that, the criminal penalty for that, is a £100 fine or £50 fine if you pay it within 14 days. So the question is, how is it that you can be criminally responsible or criminally liable for not wearing a face covering on a bus or a train or a coach or a boat? But at the same time, there is absolutely no requirement on you as an employer, either you yourself to wear a face covering whilst you're at work, or to demand that your employees wear a face covering when they're at your place of work as well, thereby, in theory, increasing the risk that others may contract a virus that they may have that they don't know that they have. And that leads to another question, which is that given that at least insofar as public transport's concerned, there are uses for face coverings and they are deemed to be suitable to be worn in order to protect your fellow travellers, are they or should they face coverings be also deemed appropriate or suitable under the PPE regulations for those who wear them at work? If they're not, the guidance currently that they're not suitable, but why aren't they suitable? And should they be suitable? And the other point to raise, and this again from information I gleaned only this afternoon from Boris Johnson's latest pronouncement in the House of Commons at lunchtime, was that he's reducing the 2 metre to 1 metre social isolation distance, the distancing measure. But that if you have to get closer than 2 metres for whatever reason in a shop or an office or a library or somewhere else, then one of the items of mitigation or the steps in mitigation that you're encouraged to take is to wear a face covering. So given that that's all the case, one wonders whether how long the HSE guidance can continue in its current form, and if it does, whether there is to be litigation, and I predict that there probably will be litigation about the need for face coverings at work, where there's so much guidance elsewhere to be wearing them. And remember, another ripe area for litigation is that according to the PPE regulations, the need for PPE is only such except where the risk has been adequately controlled by other means which are equally or more effective. And so now you're left, and employers will be left, and the litigation, I think, will centre on the question over whether the need for and the wearing of face coverings is equally or more effective than social distancing. That's going to be the argument, because if wearing a face covering is not necessary or suitable for employers and employees, but social distancing is still being encouraged at work, then according to the wording of the regulations, then social distancing is only good enough in place of PPE where it's as good as or better than PPE. But the question mark is social distancing more effective? Is PPE more effective? What PPE are we talking about? Are we talking about social distancing of 2 meters, which is continues to be the current distance, or the 1 meter that we are about to go down to? There is a marked lack of scientific consensus, political consensus on the question. So it could lead to some very, very interesting litigation arising. And I wanted to show you, when we talk about social distancing and the efficacy of it and how useful it is, and whether 2 meters is enough or 1 meter is enough if you take mitigating measures. Some of you may have been aware of this very useful little clip from the Finnish Meteorological Institute. It's only a couple of months old, and you'll see when I click play in a moment, the impact of a single person at the bottom of the screen coughing, at what impact, how far the germs and the virus would spread and over what period. So if I press play now, and you'll see at the top of the screen, you can see the minutes. At 1 minute, that cough, and now at 2 minutes, the germs are up to 3 meters in the air. 3 minutes, the germs are still moving around. 4 minutes, 5 minutes, and 6 minutes. So one can see there, the purpose of that little clip is to show that even at when one emits a single cough, when one is standing tens of meters away from from your nearest fellow people, whether it's fellow employees or shoppers or whoever, your germs continue to spread through the air for a very long period of time. And whether the distancing measure is 1 meter or 2 meters in this country, is that enough in any case? And would the provision of a face covering be more effective than keeping a distance of 2 meters away? So there are some very interesting questions that may arise from this. The other government guidance that that we have suggests that, well, the government has produced what it calls 5 steps to working safely. And very interesting that those 5 steps include guidance as to what employers need to do where the 2 meter rule can't be met. And it outlines 6 potential measures in response, none of which includes the wearing of a face covering. So those measures where employees can't stay 2 meters apart from each other includes risk assessments, hand washing, working from home, so on and so forth. And each sector is provided with different government recommendations and guidance. And in none of the sectors is the wearing of face coverings recommended by the government. And I'd remind you what the HSE said, that the wearing of face coverings is only optional. So that, I think, is going to be the likely battleground, at least for the time, or to begin with. And even if the government were finally to recommend the wearing of face coverings at work and elsewhere, there are myriad questions that will arise from such a recommendation. So, for example, would the introduction of the need to wear face coverings at this stage, 3 months after lockdown, itself be deemed negligent? And should the government have done that much earlier on? If there is to be, employers are required to introduce the wearing of face coverings and gloves or whatever other PPE. To what standard? Because there is a variety of filtration efficiencies in the various face masks that are now available, and there is no standard for non-medical masks, so that the British Standards Institute says that it would be very useful if the government did indicate what an appropriate level of protection in face coverings might be. And that's got to be important, it seems to me, because where you can be criminally responsible for not covering your face on a bus, and you only cover your face with tissue paper, as opposed to something much thicker and more protective, although you're not breaking the law, actually, are you still is your face covering still serving the purpose that it was intended to serve? And equally at work, if an employer is going to provide inadequate PPE, face coverings or gloves, does that serve its purpose? Arguably, no, it doesn't. But all of these questions are ripe for litigation. And there are a variety of other what-if questions. What if, after a risk assessment, a defendant chooses to provide PPE to his or her employees, but then can't source adequate or suitable PPE, and so tries to make do with something else that's not quite as good? Will that render him or her liable in negligence? Or does that go to the question of what was reasonably practicable in the circumstances that that employer was able to obtain? Again, it's all going to rely on the facts and the circumstances of each case. What if PPE that isn't compliant with the latest 2018 regulations, which enable PPE to now be compliant with EU law? What happens if non-compliant PPE is available, but compliant PPE is not? Is likely to be, what about the question of causation? How do you, that wearing of, or the non-wearing of the face mask was the step or the omission that led to the claimant contracting COVID-19 at all? So it's a problem, because the but-for test, it seems to me, is going to be very difficult to establish when there are so many other potential causes of COVID-19. An employee who simply goes to the shops or answers his or her front door, or sees a relative or a friend, could just as likely have caught the virus from that source than from his or her failure to wear PPE at work. Material contribution, is it going to be enough that the non-failure to wear a face covering has contributed in a material way to contracting COVID? Well, that test, the material contribution test, tends to arise where we're dealing with divisible injuries, so noise-induced hearing loss, for example, or injuries where one can divide up doses to divide up fault. Maybe the causation test will be whatever is a material increase in risk. If the failure to wear a PPE or a face covering or gloves materially increased risks by more than 50%, which is the test in mesothelioma cases, then that may also be sufficient to establish causation in COVID-19 litigation. It all remains to be seen. Now, that's enough of PPE. Moving on to the control of substances hazardous to health regulations. These are the regulations that impose obligations on employers to assess risks posed by substances hazardous to health and to control them so as to so potential exposure in the workplace is reduced to the lowest level reasonably practicable. Now, what is a substance hazardous to health? It means a substance, according to Regulation 2.1, which is a biological agent, and for our purposes, that would include a virus. So the COSH regulations would apply to employers in terms of any employees who may contract the virus whilst at work. But does that mean that any employer is potentially liable to anybody arising from anybody who catches COVID-19 at all? And the answer to that is no, because Regulation 2.2 says that in these regulations, a reference to an employee being exposed to a substance hazardous to health is a reference to the exposure of that employee to a substance hazardous to health arising out of or in connection with work at the workplace. So whoever the employee is who might be interested in bringing litigation arising out of the COSH regulations, it would have to be somebody who's been exposed to the virus arising out of or in connection with his or her work. That's to say, somebody who works in a hospital, somebody who works in a care home, or somebody who works in a GP surgery or provides medical treatment in some other way. The code of practice which accompanies the COSH regulations emphasises that COSH doesn't cover a situation where one employee catches a respiratory disease from another employee. This is because Reg 2.2 specifies that COSH only applies in those circumstances where risks of exposure are work-related and not those where they have no direct connection with the work being done. So that will limit quite substantially the extent to which COSH will be able to be used by employees in PI claims being brought against their employers. And that must be right, because if you think about it, it would be wholly wrong for employers to have to take measures to prevent infection amongst their workforce from viruses that the workforce could just as well have acquired in the community or from other sources. So there has to be a measure to prevent infection that has something to do with the work that the employees are actually performing. There are other types of employers' liability cases which it seems to me are likely to be brought in one guise or another. The first is inadequate training. Those employees who, for example, were not furloughed whilst others were right at the start of lockdown, or those who've seen their workload increase, or weren't trained for the work that they had to start covering back in March. If they weren't trained and they've suffered injury as a result, then they're perfectly entitled to bring an EL claim against their employer. Similarly, workplace stress type claims. There'd be nothing surprising to see claims being brought by workers who are having to homework, who never had to work from home previously, who weren't set up for it, who don't have the tools, whether technological or physically simply don't have the tools to do it from home, but whose requirements and obligations whilst at work have remained the same. And depending, of course, on the state of knowledge of the employer, so if the employer was told and it was foreseeable to that employer that an employee was suffering in this way, then there'd be no reason why that employee might not bring a workplace claim arising out of his COVID injuries, arising out of his being or her being at home and being overly stressed because of those extra requirements. Equally, repetitive strain or ergonomic type injuries, those of us who are now working from home who don't have the chair they had in the office or don't have the necessary equipment or the mouse mats and wrist pads and all the other paraphernalia that prevent RSI, then that's also fertile ground. And equally, workers, for example, construction workers who were furloughed initially or who weren't able to work initially, who were required to meet deadlines and who are still required to meet deadlines, but who have got much less time to do so now. If those workers or the employers of those workers now seek to cut corners to ensure that those deadlines are still met, then inevitably that is also going to lead to PI litigation in the future. That's child one, employer's liability. COVID's child two, and I can race through these rather more quickly. Public liability claims. And of course, these can arise from any failure to take reasonable care, really to anybody visiting a shop, a library, a gym, a religious place of worship or anywhere else. And there are all sorts of questions that, factual issues that are going to dictate the prospects of success of PL type claims arising out of the COVID-19 pandemic. So, for example, shops that open before they should or before they were guided to open. So non-food shops, for example, who've remained open throughout, notwithstanding the risks to its customers. Non-essential shops, for example, but who simply didn't obey the rules. If somebody catches COVID-19 in one of those shops, are they going to have a cause of action? Possibly. What about cleaning systems? If a place of worship, a cinema, or a shop doesn't adequately clean up, deep clean on occasion, schools the same, don't deep clean, don't protect those who are visitors to their premises, and as a result of that, one of the visitors catches COVID-19, then it's inevitable that the argument will be that there simply wasn't reasonable care taken in that public place. Much is going to depend on the state of knowledge of the particular occupier in question. And as I said earlier on, the government has provided sector by sector guidance on these questions. And so if there is deemed knowledge in one particular sector, perhaps the delivery sector or places of worship sector, for example, and there are things are known that aren't followed, states of knowledge are known about and not followed, then that may also lead to litigation. The difficulty with these issues, as with all of these cases, is how do you prove it? How do you establish that it's the negligence on the part of the occupier that has led to your claimant, your client contracting, or indeed the claimant, your opponent contracting COVID-19. Very, very difficult to prove. Now, much easier to prove in a case, for example, like Mr. Talati, as if you remember, he was the clinical negligence claimant that we started off this talk speaking about, who's bringing the action against the government. Much easier if, for example, a whole family has attended one single shop and no other shop, they get home and within a matter of 4 or 5 days, they all suffer the symptoms of COVID-19. Now, in that case, causation might be much easier to prove, but generally speaking, it is going to be difficult to make out causation in the majority of cases, and I suspect that's going to be where the majority of these cases fall down if they ever do reach the trial stage. What arguments may be open to defendants? Well, Valenti is one, that the claimants have taken the risk. They were aware of the risk of going shopping, of going to the cinema or wherever else they went. They took the risk, they knew that what the risk was, and therefore on their head be it. It's a potential defence, again, depending on the factual matrix behind the case. But equally, contrib. If there is a shop with a sign that says 2 people in at once, please, or 3 people in at once, please cover your face, or whatever it might be, or wear gloves, and that advice isn't followed, then there's every chance that that the occupier may well argue contributory negligence, probably, seems to me, with some success. I've dealt in a roundabout way with clin neg. That's to say cases in which COVID may be acquired in hospitals or GP surgeries or in care homes. Again, difficulties in causation, in proving that, that it was the act or omission of those providers, the healthcare providers, which has led to the COVID-19. There are other difficulties. One of the big problems with causation is likely to be the inaccuracy of the test kits, which I read something like 30% of test kits, up to 30%, may be unreliable. So how much can claimants rely upon positive testing kits, or indeed double negative testing kits? And equally, if people are in hospital for unrelated reasons but contract COVID whilst they're in hospital, if they want to argue that they've contracted it as a novus actus, as a result of negligence on the part of hospital staff or GP staff or care home staff, then the negligence of those people needs to be gross negligence, and so it's a higher hurdle to get over. And finally, it may simply be, in terms of policy, there may simply be no desire or appetite on the part of claimants to blame healthcare workers who, with good reason, are considered to be the heroes of the pandemic, and who've gone well above and beyond, in many cases, their requirements to help and ease the plight of so many people up and down the country. Now, it may be that the government will take action against clin neg claims arising out of COVID. It may be that there's simply no appetite from claimants to bring those sorts of claims. But it seems to me a pretty sure bet that the government is not going to allow a pile-on onto the NHS and on clin neg settings and care homes for all of the reasons that I've given. Motor claims. Now, it may be that simply because of COVID-19 that we don't see an avalanche more claims, although we may see an increased number of claims. And watch out for those. If we do see more claims, it would be surprising in one sense because, of course, people haven't been driving very much for the last 3 months. So to see a huge increase in the number of motor claims between March and June 2020 might raise a few eyebrows. Having said that, people's financial situations are much more difficult now than they were, and it may be that those who are perhaps less scrupulous than they should be see staged motor collisions or exaggerated claims as a way to make some additional money, particularly if they're on furlough or their income has dropped substantially. So watch out for that, and be alert for fundamental dishonesty issues and Section 57 issues arising from motor accidents from the first half of 2020. But even in those standard sorts of motor claims leading to PI and other consequential losses, you can expect to see longer vehicle storage and repair periods, longer hire periods, simply because people aren't in the office, they're not working, they can't respond as quickly. Repair garages may be working at a reduced service, may have difficulty obtaining car parts. And so my advice to insurers and to defendants would simply be, if these are likely to be issues, and I think they are, perhaps look at the broader picture, and earlier payments, PAV payments, might be one way to try and mitigate against the effect of increased repair, storage and hire charges. Now, I have a few minutes left, and in that time, I call this slide COVID the Parasite. What do I mean by that? I mean, how is COVID impacting, or how is it likely to impact on existing personal injury cases? Not necessarily causes of action, but heads of loss in particular. And there are really 8 areas which I'm going to gallop through extremely quickly. The first is procedure. We've dealt with this to a degree already, but obviously the delays caused by COVID-19, the extensions that are going to be required, the delays in medical reporting, difficulties with service, limitation, and so on, that is going to impact on all existing litigation. But it's obviously, I say COVID as a parasite because that is the trigger. COVID is the trigger for those obvious difficulties. Equally, COVID is going to lead to a higher risk of mortality. Those who, where claimants spend substantial periods of time in hospital, if very serious injuries have led to long periods in hospital, and we know, particularly in the early stages of the lockdown and before, when hospitals were really under pressure and COVID was spreading through them like wildfire, being in hospital was linked with a higher risk of mortality and with injury complications as well, all of which could lead to longer recovery periods and increased deprivation. And has particularly affected older people and those in BAME groups as well. So if there's no vaccine found soon, life expectancy is going to change in those and possibly other groups as well. If NHS services take a very long time to return to normal, then that is also going to have an impact on life expectancy. How is that going to affect PI litigation? It's going to affect multipliers. It's going to affect discount rates. It's going ultimately, once the actuaries do their work, we are going to see changes as a result of the impact of COVID upon people's life chances generally. Loss of earnings claims. Now, I also see COVID is likely to have a very substantial impact on claims for loss of earnings, particularly future loss of earnings, because if somebody sustained pre-lockdown injuries and, let's say, lost their spleen, which made them much more liable to, vulnerable rather, to injuries and diseases and infections. If as a result of it, they've had to shield for the last 3 months more, and as a result of having shielded, they haven't been able to go to work, they haven't been able to go out, and so on, then those losses arguably are COVID related. They wouldn't have had to shield but for COVID, they wouldn't have sustained the losses that they have but for COVID, and therefore arguably those losses will result from the contracting of COVID. And equally, furlough, if but for the index accident, somebody would have been furloughed, would have lost their job, wouldn't have found another one, irrespective of the index accident. The loss of earnings claims are going to be heavily impacted by COVID and its consequences. Equally, discount rates, the cost of care, impact on treatment and rehabilitation. How can very badly injured claimants be properly treated or rehabilitated if they can't access the treatment that they need? If they have to self-isolate, it's going to be very difficult for them. And equally, being in lockdown or self-isolation for periods of up to 2 or 3 months is going to affect their psychological state, and that in turn is likely to increase their claim for general damages potentially as well. Finally, alternatives to going to court. We've all learned a huge amount because of COVID, what the alternatives are, that we can do application hearings and CCMCs, and in some cases, some contested hearings by either telephone or by video. It's not the end of the world. JSMs can occur in this way, that there's a place for early neutral evaluation as well. But ultimately that each case is going to turn on its facts, and as to whether the courts are more likely and more willing to deal with cases virtually. I think the answer is absolutely they're going to have to. And if that means not having to trek down to Plymouth for 4 hours each way for a CCMC, then it may be that that's no bad thing. I'm going to call it a day there. I see it's 5:30. I'm going to stop sharing my screen. And I don't know if anybody has any questions that they have or would like to ask. I can't see any on my Q&A tab here, so I think that's probably a no. Thank you for joining. Thank you for listening. For those who are still with me, I apologise for my technical difficulties there. But as I say, thank you again, and I hope to see as many of you as possible, or I hope as many of you as possible can join us next week for the next webinar in the series, which I believe is going to be about e-bundles and preparing for electronically for virtual hearings. So thank you again for joining, and I hope to see you all very soon. Goodbye.